Great. Well, it looks like folks are able to get into the webinar, and I want to welcome everybody this morning to the first hemp webinar of a series that we'll be doing over the course of the summer to keep people connected to what's happening in hemp. And I think our inability to really have in-person field days and such right now is meaning that we're going to try to connect with everyone virtually as much as we can. So welcome again. Looks like our attendees are in now, and just see the numbers aren't going up anymore. So great. So good afternoon, and welcome again to the first webinar in a series of webinars that we will be holding this summer focused on hemp. The first one today, we do have another webinar next week, same time, called Getting Ready for the Season, Getting the Season Started with myself. This is Heather Darby from UVM Extension, and John Bruce, who is also extension specialist working in hemp at UVM. So I just wanted to welcome everybody this morning. I don't know if everyone is getting the rainstorms we are here up north, but some well-needed rain to get the crops up and growing a little bit better. We planted our hemp at UVM, most of our hemp, not yesterday, the day before, so it'll be good to get it watered in as well. So I'd like to start the meeting by introducing Susie Hodgson and Catherine Davidson, both from UVM. They're my partners in crime on a project that we're just getting going from the Northeast Risk Management and Education Program. And so I'm going to turn this over to Susie to talk quickly about our project, and then over to our guest speaker, Stephanie. So Susie.
Yes, hi, thank you, Heather, and thanks for everybody for joining this webinar. As Heather mentioned, we have this project team and we're just getting going. So our sponsors are the USDA Northeast Risk Management Education. So the focus of this project is really on the education, and we're all on the learning curve. As we know, hemp hasn't been federally legal for that long, so we're learning as you're learning. And with a focus on risks, we're going to be covering different kinds of risks, but in this webinar, we're going to be looking at the legal aspects and compliance. As Heather said, next week we'll be more focused on production, all about growing and cultivation. Later in the season, we'll be talking more about marketing and labeling, having a webinar for that. And then we'll circle back to the legal by having a sampling and testing of hemp in August and September. So we'll be capturing questions and issues as we go along. Our aim is to produce some fact sheets and other guidance and FAQs for everybody as we go. But today it's all about the new Vermont Hemp Rules. So I'm going to pass it over to Stephanie Smith. She heads up Vermont's hemp program at the Vermont Agency of Ag, Food and Markets, and she's really here to help farmers and help us all. So she has a PowerPoint presentation which she will share shortly. While she's speaking and you think of questions, use the chat and we'll address the questions after Stephanie's presentation. And if we can't answer all your questions today, which I'm sure will be the case, we'll be recording this webinar and then we'll be able to circle back with FAQs to help us all as we make hemp a successful crop in Vermont. I mean, it's a big year of uncertainty, so we're really gonna focus in on these risks and help to kind of reduce them in this project. So thank you, Stephanie.
Yeah, thanks for having me. So I wanted to say that the Agency of Agriculture has completed a year-long process of rulemaking. Actually, it's probably over a year because we did a lot of drafting before we actually filed it with the Secretary of State's office. I believe it was on May 17th of 2019. But we have filed our adopted rule with the Secretary of State's office. And so those rules are in play at this point in time. The rules in which, in any presentation anyone's ever seen me make is primarily to set expectations of growers and processors in the state of Vermont. to enable communication with various stakeholders in hemp. That's not just law enforcement, that's not just the Agency of Agriculture. This includes banking and insurance companies and others as well. We are also, the rules are also about protecting consumers of hemp and hemp products in the state of Vermont, and also to protect the Vermont brand. So I'm just generally going to provide a very broad overview of the rules, and then also answer some frequently asked questions that we've received, and then share resources at the end for where you can get some of your questions answered. I want to start off by specifically, defining what hemp is. Hemp has the same plant is also high THC cannabis, and our hemp program, or the hemp program, it's titled, is just for regulating hemp for those reasons that I articulated earlier. I'm also going to talk about the effective date of the rules and what that means for those that are participating in our program, and then address certain sections of the rules, however, not all sections. First off, though, I want to give some statistics for this year, because I haven't had an opportunity to actually share that many beyond within the organization or within the agency itself. But to date, we've issued 399 registrations. 339 of those registrations are for commercial growing and processing activities and/or processing activities, and then about 60 for personal use cultivation of hemp. It's approximately 1,177 acres. We continue to receive applications for registration, so this is not a final number in the least. We expect it'll continue to grow, certainly over the next month and then possibly even into the future. It's a rolling registration process. And for processors, they can come in and register at any point in time, obviously, if they're starting up a business. And so again, it'll roll throughout the year. We have 7,000 this year. For the first time, we're able to actually capture how many square feet of indoor cultivation we have, and currently it's 7,893. We have 11 issued for grain and fiber, and then 48 registrations have been issued for hemp extraction, just so people are aware of, and this is in the state of Vermont, obviously, that there are folks that are providing that service. In 2020, the hemp program expects to operate under the 2014 Farm Bill. So what does that mean? That means that we are obviously abiding by the federal definition of what it means for a plant to meet the definition of hemp, and that is that it tested, has a THC concentration, a delta 9 THC concentration less than or less than 0.3%. In the state of Vermont, we have an additional limitation of not any more than 1% of total theoretical THC concentration, and that was in the interest of protecting consumers, as we know that a lot of when you're testing hemp, the THC doesn't always come out as delta 9, and so we were setting an upper limit of what can be combined with the THCA, the THC acid, in order to meet the definition of hemp. This authorization for the pilot program in the state of Vermont, nationally, will expire on October 31st of 2020. So what this means for growers in the state is that you must grow, sample, test for potency, and harvest before October 31st of 2020 in order for your crop to be considered cultivated under the state of Vermont's pilot program. If you take any of these actions post October 31st, you will need to register, at least you may be registered with the Agency of Agriculture. We do intend on submitting a state plan to the USDA for approval, but until we get that approval, it's possible that you will have to register with USDA in order to cultivate or harvest your hemp that you otherwise grew earlier in the year. So what is hemp? So it's the cannabis plants and any part of that plant, including seeds and derivatives, extracts, cannabinoids, salts, acids, isomers, yada, 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 going on, that meets the federally defined tetrahydrocannabinol concentration level. And this is actually the definition from the state of Vermont. We just internally within our state of Vermont referenced the federal definition, just in case that changed at any point in time. We didn't want to, not that there's an expectation of that, I'm just saying, that we didn't want to be held to a Vermont definition that was otherwise not tied to the federal definition. So when do those Vermont rules come into effect? This happened 15 days post the agency filing our rules with the Secretary of State's office. And so they came into effect on May 21st of this year. Are there any sections within the rule that have a delayed implementation date? No, everything's in play currently. But the agency understands and has a practical approach to applying the regulations. We know that there's going to be a fair bit of learning curve, and we appreciate the opportunity today to talk about the hemp rules and what they mean for growers. So again, we're practical people. We're not coming forth with a hammer. However, we also want people to know that we will still investigate any complaints and respond to any concerns that are raised by folks in the state of Vermont regarding either the cultivation and or hemp products or hemp infused products. But we're reasonable people. So there's lots of aspects of the rule. I'm going to go over a number of them, and we can kind of talk and break it apart as to what's like to answer questions regarding how we're going to move forward with applying the rules in the near term. But we have enforcement discretion. I think most agency regulatory enforcement have some discretion in applying their rules, and assuming that it's not an egregious and otherwise horrible thing, the agency is likely to use their discretion in the near term in enforcing these regulations. Let's see here, moving on. So who needs to register? We actually get this question a lot. Everybody who is growing hemp in the state of Vermont needs to register, whether you're growing for personal use or you're growing for a commercial product to be sold or to be sold to a processor. You must register with us. The cost for personal registration is $25, and then it increases based on the scale of your operation. And when should you register? You should register before you take possession of any viable seeds, plants, and or clones. Registration would be required for nurseries that are growing hemp plants. Even if they're not going to bring them to flower, they'll need to register with us. We have registration requirements for indoor and outdoor cultivation. One per plant for you to cultivate outdoors, up to, for personal use, up to just under ½ acre. Again, you need to register with us. Also for processors, you need to register with the agency, and processing includes providing the service of processing and or drying or storing other people's hemp crops. But you should do it before you take possession, again, of any hemp crop, a trim flower, or a hemp concentrate. So hemp concentrate may only be possessed by a registrant, and a hemp concentrate is defined in our rules. Oh, I wanted to mention, everywhere you see an underline within this presentation is a term that is specifically defined in the agency's hemp rules. And the most important section of any rule in any regulatory process, or from a regulator's perspective, is actually the definitions. They will provide you a tremendous amount of information and help you interpret those rules. But of course, the agency's here to help interpret those rules. So who's a grower? And we actually have a frequently asked questions kind of guidance sheet on our website here at the agency that explained who a grower is. Growers, well, growing, let's start there, includes all aspects of cultivation and harvesting of hemp. You know, you're starting your seeds, you're in a greenhouse, that's growing. You need to register that location for that activity. All these registrations can be included on a single form, and I'll get into that a little bit more later. Growing includes drying hemp. It includes storing hemp if you grew that crop. And that facility for those activities need to be registered. Growing includes any kind of pruning activities out in the field and or bucking at harvest. Bucking, removing, just generally removing the flowers from the harder stem. That is all included within what is considered growing. For processing, if you're going to trim hemp flower for a finished product or any kind of trimming activities, that is considered processing. So you might be registered as a grower, you might decide to trim your flower, and then you might throw it in a bag and sell it to the consumer. That is a processing activity by the time you get to that kind of hands-on, or even, I know there are machines out there, or equipment out there that does some trimming as well, but that is considered a processing activity. If you're storing hemp from a previous year's crop, that is considered a processing activity. We've made this determination only because it's, we don't want people to feel that they need to register a growing activity when they're not actually growing, but we do include storage and drying as a processing activity. But primarily the reason we're doing this is to ensure that we are able to communicate to individuals that you are still registered with the agency, and that location is registered with the agency, and it's legal to operate that facility from the prior year's crop. Let's see here. Oh, and both growing and processing includes transportation of those crops between places. Obviously, you're not going to register a location there, but individuals can transport their crops, and a processor can transport somebody else's crops to their place of processing under their registrations with the agency. So who doesn't need to register? This is as important as the question of who needs to register. I think it's also helpful to address who doesn't need to register. So I did say earlier, if you're growing for personal use, you do need to register as a grower. But if you're processing the crops that you grew for yourself and you're processing them for yourself, you do not need to register as a processor necessarily. Your registration for your own personal use is captured within that growing application. Retail establishments do not need to register in order to sell hemp crops or hemp infused, or not sell hemp crops, to sell hemp products or hemp infused products. The only exclusion for that is a nursery. We would consider a start or a clone to be a hemp product. And nurseries do need to register with the agency for the growing activity. They also need to register as nurseries. If you're selling live plants, you need to register with the Agency of Agriculture, not through the hemp program, but through our nursery program in order to sell live plants. I think there might be an exemption for minimal sales under a certain dollar amount, but I don't have that number off the top of my head. Service providers, this is different from last year. Last year's registration fee was $25 flat for any activity. And so when individuals were saying, well, I'm providing an agricultural service, I'm bucking, I have equipment specifically, and I'm providing the service on the farm that's registered with you, we had initially requested that those individuals register with us for the $25 fee. Due to the change in fees and other items, if you're providing an ag service at a registered location for a registrant, you do not need to register, you providing the ag service do not need to register with the agency for providing that agricultural service, even though you may be handling the crop. You're working under another individual's registration, and that's fine. And likewise for transportation providers, if you someone is transporting crops for another individual, making sure that that transportation company has a copy of the registration and certificates of analysis for potency with them, and they can operate under that other person's registration. Those transportation providers do not need to register with the agency. So new fees, these were adopted by the legislature last year. And they applied this year. I'm sure those who have registered already are probably aware of this. And I just wanted to draw attention specifically to, I mean, the fees are pretty self-explanatory, but I want to draw attention to indoor cultivation, as that's a little new and different for this year. So for indoor cultivation, the agency, what doesn't count as indoor cultivation is plants that are started in a greenhouse that ultimately are destined to be brought to maturity outside. You don't need to register under an indoor cultivation permit for that specific type of activity. The indoor cultivation is bringing crops to flower under light, artificial light, and for successive crops. So like every 60 days, you're growing plants and harvesting, growing plants and harvesting. That's indoor cultivation for folks out there that are engaging in that activity. And then again, for those that are just operating a greenhouse in order to start their plants, this particular registration fee and type doesn't apply. I wanted to also say that when you register with the agency, currently on our website, we have a fee calculator that can help you figure out what your fee is before you make plans, as the fees are significantly more than they were last year, so that you can understand what your obligation might be to the agency when you register. So now, like, really digging into the rules, and I'm gonna hopefully, I have all the section references as well in the next couple of slides, or several slides, so that you can, if you have a copy of the rules, you can follow along, or you can go and find information at a later date regarding registration in this instance. It's found in section 4 of the rules. It's generally mirrored with respect to what's outlined in Vermont law. Some new pieces, however, and it's also, the process isn't much different from last year, a little bit different. But those who registered last year, those expectations are very much the same with respect to mapping and providing us contact information, email. We do a lot of communication through email with registrants. But some new things this year is that you can register your entire operation on a single form. We don't have a separate form for growers and processors. When you register and we give you a registration, you are bound by the scale of the operation that you submitted your application for. So if you're going to grow if you're growing for personal use, your crops cannot enter into the market. And so you need to abide by the registration that's been issued to you, as well as for the commercial operations, there's tiers of cultivation, and you just need to abide by what you applied for. The other thing that's new is that the fees are based on the greater of the number of acres planted or the weight of hemp processed. So if you have a small cultivation operation, but you're primarily a processor, then the processor fee that's greater is the fee that you would pay. 5 and 6, these sections address record keeping and reporting. I want to say something about this. These are actually, this section 5 and 6 and 7 and 8 are the sections that we're getting the most questions about, is they are new, like registration. We all know we have to register. But 5 and 6 are generally a little bit newer and a little more stringent than they've been in the past. But I want to say something about record keeping. So the function of record keeping is to understand what is happening in the Vermont market. We can identify through you keeping records and or us inspecting your records, we can identify bottlenecks in the market. We can understand where crops are moving within the state of Vermont or outside the state of Vermont. We're able to compare information year over year if we have access to these records and you share them with us. It also helps us, like for instance, we're requesting that individuals keep information regarding the cultivars that they're purchasing and planting. And if we get potency data or certificates of analysis regarding potency, we can identify what cultivars are actually successful in our state and otherwise are consistent year to year. And so this is primarily it's a requirement of the rules, but it is a focus of supporting the industry in the state of Vermont, or that's how I feel. As well, it's a consumer protection tool. And honestly, this whole industry, everyone's a consumer. Someone's buying plants. or seeds from somebody. And then somebody is buying that crop from a grower, or processor's buying that crop from a grower. And so everybody actually serves the role of a consumer. And in keeping track of this information, we are able to hold individuals accountable if somewhere in that process it breaks down. It also helps us sleuth where issues may arise. And so I think it's really important, and it's not, it's to support the industry. So here, this is the reporting requirement, and this is generally actually for us, the agency, to be able to report to the federal government. This total acres planted, harvested, and disposed is a requirement under USDA's interim final rule. While we're not actually operating under that right now, we're still going to collect that information. It also helps us with marketing or understanding the industry in the state of Vermont. And then for processors, we want to understand what our capacity is. And so at the time of registration in a subsequent year, we're interested in understanding how much crops were handled and a dry weight estimate by each processor that's registering with us. And it'll help us understand, what, if you're paying the right fee as well, obviously, but again, to help us understand the market. I wanted to say that a little bit about organization of the rules. While the registration section kind of generally applies to both processors and growers, a number of the other sections, like in the middle of the rule, are broken apart where they're just addressing grower or they're just addressing processor, so that individuals can go directly to the section that applies to them, rather than it being organized like record keeping for everybody, and that we just felt that it was an easier way for the customers of the agency to follow the rule. These two definitions are really important. While they're defined in the rule, there's also an opportunity for our registrants to further define how they're going to implement these definitions as a part of their business model. And understanding these definitions can affect your business model. So for instance, under harvest lot, a contiguous area in a field, greenhouse, indoor growing structure containing the same variety or cultivar of the plant throughout that area. And so depending on, if you have lots of really small lots that you're growing on and you're growing all the same cultivar, know that the harvest lot and the decisions you make about testing are going to be impacted, and the costs generally, you will be impacted by that because you have to test by harvest lot. So if you know that you're going to have the same cultivar and you want to reduce your costs, you may want to grow in a larger area. And then on the other hand, you might buy a cultivar that might mature earlier, or you want to try different types of cultivars, in which case you might have a different opportunity, but know that you have to test by harvest lot. Under process lot, similarly, you do as a processor have an opportunity, besides this being the definition, you can define what your standard operating procedure, I'm starting at the bottom of the definition, the standard operating procedure you use for developing that particular lot. And if it's different for each different little process lot, then your testing requirements, again, you have to test by process lot. You can define your time frame for when you did your processing. It could be over 4 days, and then all those individual extractions can still be a part of a larger process lot. But the process lot is the basis for the testing that then goes into a product. If you wanted to do really small batch or unique products, and you're willing to do the testing associated with that particular extraction for that process lot, you're more than welcome to do so. And then you could potentially use that as a marketing piece about this being a small batch in a particular area of the state or whatever. But the costs are greater when you work on a smaller scale. So testing, those are in sections 7 and 8, 7 for growers, 8 for processors. And it just provides information regarding when the agency has identified like critical control points for when there's a potential for an introduction of a contaminant. And so we're requiring testing at various points within a process, from cultivation all the way through finished product. I just wanted to be clear that there's no opportunity to mitigate hot crops. If it's a crop that exceeds the acceptable potency level as defined in the rule, while technology exists to mitigate the THC concentration, that is not considered hemp under the rules, and therefore it's not a crop that can be brought through the system or further made into products, despite the fact that technology exists to remove THC. These crops would have to be destroyed. I just also want to acknowledge that there is some provisions in state law to allow for a farmer or grower to sell the crop to a medical cannabis licensed operation that can then do further processing and then give it back to the grower, or otherwise move it through the system. That is not available, even though it is provided for in Vermont law, only because under federal law that is not permitted, and we didn't want to put farmers at risk for penalties and potential prosecution by allowing hot crops to be moved through the market in the state of Vermont. So that is not an opportunity. However, there is potential for mitigation that for crops that do not meet contaminant action limits. I understand that some bacteria can be destroyed during a ethanol-based extraction process. And so there is an opportunity. And so again, in the critical control points for when we define when testing can occur, there are opportunities to mitigate some of the, for some of the crops that exceed the contaminant thresholds that will be established. Testing is supported by the Cannabis Quality Control Program, and that program, again, identifies contaminant thresholds and also will certify labs. This is also part of, in the rule, there's a section that addresses the Vermont brand, and this Cannabis Quality Control Program it supports that Vermont brand. The Cannabis Quality Control Program is going to set expectations for laboratories that conduct testing for our regulatory purposes. Those labs that become certified are kind of a partner with the agency in compliance of both growers and processors. And you're going to hear more about that at a later date, so I'm not going to spend a bunch of time on that. We do have a reporting requirement in the rule for when crops exceed the acceptable potency level, that they need to be reported both by the growers and the laboratories that are conducting testing. So here's that table that's found both in our, well, it's currently in the rules and will be found in our Cannabis Quality Control Program documentation. It again identifies critical control points and provides for when testing should occur. There's a lot of information here, and I'm not going to spend a whole bunch of time talking about it at this point in time, but we're available to answer questions regarding this table. But some of the tests that are done at earlier stages, like some harvest lot testing, does follow the crop through the process. And so this doesn't mean you need to test everything at every point. But there is still some significant amount of testing that needs to be done on crops. And again, this is in support of the Vermont brand and the industry in the state of Vermont. So we get this question, are there any certified labs in Vermont? Currently there are not. We're working on it. We're hoping to start standing up the program or getting it together by late August and get some labs registered. So that they'll be available for harvest season, maybe this year. Does that mean people don't have to test if there aren't certified labs? No, people should still test. They just may not be using certified laboratories. Does a processor need to test every batch or process lot? I use batch as well, even though that's not a word defined in our regulations. We use the term process lot. Post-extraction. And so the answer to that one is, if you are using a process lot and you've identified that process lot as a basis for a product, then yes, you will need to test all process lots post-extraction in accordance with the table that was on the previous slide. If I don't offer a label guarantee regarding cannabinoid content, do I need to test every process lot of product? And this is for a finished product piece. If you're not providing a label guarantee, you do not need to test every process lot. The assumption is, and this is articulated fairly well inside the rule, if you're starting from the same point, so use the same hemp extract with the same cannabinoid levels, and you have a standard operating procedure for how you put that product together, including ingredients, bake time, mix time, like the whole process, and it results in a product. If you follow that every single time, you would not have to have a test for every finished product. The fact that you have the same ingredients throughout the process is enough for providing information regarding labels. Labeling. So this is a section obviously in the rule, section 11, and these are the requirements for what needs to be on packaging. We do get the question frequently, do I have to change my label? And the answer is no, but the product should be labeled with this information. I think this is probably one of the bigger issues associated with processors in the state of Vermont, because they want to be sure that they're compliant, but they also know that they've invested in some labels already, and it'll be difficult for them to comply, especially since the rules are already in effect. Some have kind of sleuthed out a way of solving this issue by printing up stickers that they can affix to their products to supplement information that's currently on their labels that otherwise meets the requirements of the rule. But again, the agency, we're not a hammer, we're here to help. If you have questions, we want to help you and explain them. But the most important thing is that your labels are accurate. If they're inaccurate, that's problematic. But accuracy, to the extent that you have it labeled, is great. And we do want the location of your facility on that label, and we do want to be able to track that product back to its process lot, have it traceable, actually even back to its harvest lot, based on the record keeping of your organization. So you don't need to change your labels today. Again, you can print up stickers to supplement the information that might otherwise be located on your label. Should you have your process lot on your packaging? Yes, you should. You should have that, and again, that should be traceable to a standard operating procedure and to the concentrate or the extract that you used in making that product. And if it's all produced in the state of Vermont, it should be traceable all the way back to the harvest lot. Can you use a QR code on your label to meet Vermont Hemp Rule requirements for labeling? No, you cannot. You can use a QR code if you want to supplement the information that is otherwise required on the label. So if you wanted to have some kind of marketing scheme, or you wanted to talk about some other aspect of your operation, or terpenes, or some other content that you're not actually, maybe not guaranteeing, but that you wanted to provide information on, you can use a QR code for that. But otherwise, the information that the agency requires in Section 11 must be on your label. Or on your packaging, if not physically actually on the printed label. So where to look for answers? I just want to reiterate the definitions section being an important section of the rule. We also have registration guidance on our website. We have the grower and processor FAQ that I mentioned earlier. There's seed guidance and nursery guidance. We have a list of allowed pesticides on our website that you can use on your hemp crops. I know EPA has approved a number of pesticides as well for use on hemp crops, and that list appears to be ever growing. We have pre-harvest sample forms. We have guidance on how you should sample. And then we have guidance on interpreting a certificate of analysis, and most of that information is found at this website. Other regulatory processes that or regulations that might apply to a hemp operation. I mentioned earlier the nursery dealer program, but as well we register, the agency registers individuals that sell seeds in the state of Vermont or into the state of Vermont. You should register with Lisa Fantelli here at the agency. If you're a processor or an indoor grower, there's potentially fire safety division building permit requirements that you should be in compliance with. We have a pesticide program as well. Let's see here. Oh, there's, I don't think it's an S-194 anymore. I apologize for that, but I think there is a bill in the legislature that is moving to create a certified seed program here at the Agency of Agriculture. So keep your eyes and ears open about that. If you're cultivating, you have to be in compliance with the required agricultural practices. The agency has a Vermont Agricultural and Environmental Lab. We do testing, not for the general public or for the commercial industry, but that's where the testing related to any enforcement action or research that the agency does is located there. And then of course there's water and wastewater at the Department of Environmental Conservation as well. So I wanted to give you all some contact information. Mike DiTomaso, myself, and Bob Shipman are all part of the hemp program. And if you have any questions, feel free to reach out to us. And then we have a general email box as well, agr.hemp@vermont.gov. Thank you very much.
And
Great.
thank you, Stephanie. That was
Yeah.
great.
Oh, thanks, Stephanie. That was great.
I went over.
That's okay. And don't worry, there's no shortage of questions, as I bet you can imagine. And I see, I think others from the agency are on the call, as well as Annette Higbee, who is a lawyer that we have been working with in Randolph, that we've worked with for years on agricultural regulatory and legal issues. So she's joining us as well. So hopefully we can get most of these questions answered. So Stephanie, are you ready? I'm just going to start going down the list. And
sure.
hopefully we can get to all of them.
I hope I have answered. If I don't, I might not have an answer, but I think
okay.
That's, you know, like we'll answer them at a later date.
Okay. And we are recording this, and with Stephanie's permission, of course, we'll post it so people can, you know, listen to it again. And other people have asked if it's going to be available. So we will make that available. All right. And Catherine, do we have a quick poll today? Is that?
Yep,
right?
I'll launch that right now.
Okay, so we're launching a quick poll with a couple of questions. If you could answer the questions for us, that would be great. We use this to, you know, work with the folks that are providing us grant dollars to show that people are learning from our outreach efforts. So we'll leave that up there and we'll start getting the questions answered. So Stephanie, you indicate that the hemp program will operate under the 2014 Farm Bill authorization. A new Farm Bill was passed in December of 2018. Does this change the rules and provisions?
So yes, a new Farm Bill did pass in 2018, and that Farm Bill does include, I mean, it has the same definition of hemp, but there are some additional requirements regarding testing, and as well, USDA was authorized to go through rulemaking regarding state plans. But the 2018 Farm Bill acknowledged that states continue to operate under their pilot programs through 1 year after rules were published by USDA. So the rules that were published, the interim final rule, that is also in effect at this point in time, however, it doesn't impact us because we're operating under the pilot program, was published on October 31st of 2019. So we have 1 year to continue to operate under our pilot program. The state of Vermont, if we want to get primary regulatory authority of the cultivation of hemp within our state, needs to submit to USDA a state plan that is in conformance with the interim final rule. And we are still considering that. We intend to submit a plan. It's on my list of fun things to do. Actually, I got to start on it yesterday. But this does not change how we're currently operating. We're still operating under our pilot program.
All right, thank you. So remember, type your questions into the Q&A box is preferred, but the chat box is fine as well. So we have a couple questions on the lab certification. So when will the lab certification program start?
So we are continuing to develop the program. We are hoping to have an application available in August, hopefully in mid-August, which labs can then apply to. Bob Shipman is making, I think it was September 10th was the presentation. So we will certainly have more information by then and even potentially a list of labs that meet the requirements for certification. But so we're hoping mid-August we'll have applications out. Again, that doesn't mean that there aren't labs in the state of Vermont that do testing. There's certainly a number of labs that are testing hemp crops, as last year, or even outside the state of Vermont. There are labs that have done testing for growers in the state or processors. So the requirements for testing exist, whether or not it's going to be, again, a reasonable approach, whether or not that testing is going to be done by a certified lab. If we don't have certified labs, then of course not, but we're still developing that program. That's kind of a rambling answer, but I'm happy to talk about that further, and or please feel free to contact Bob Shipman if you'd like.
Okay, so somewhat related to that, somebody asked, can the testing be done with any certified lab anywhere in the US? And what certification is the lab required to have?
So lab certification in the state of Vermont, we're going to require that you have to have an understanding of the Vermont hemp program and the rules that are in place. We're going to potentially require some accreditations, and or obviously you have to have validated methods and standard operating procedures within that lab, qualified personnel. So these are some of the requirements that we're going to request of labs that seek certification. So labs a Vermont certified lab is someone that's certified by our agency within our program. A lab could be located in another state that is certified by our agency and our program. But if it's a lab in another state that isn't certified by the Vermont Agency of Agriculture, it's possible that that lab would not be a lab that a grower or processor could use. We are still evaluating the potential for some, for labs that are certified by other states, maybe meeting our standards here in Vermont, but we haven't actually got into that because we're just kind of working with just developing our program, so we don't have that those requirements for how there might be, the word is escaping me, I don't want to use, but that other states would be able to, or other state certified labs would qualify for our certification.
Okay, great. There's a couple of questions about moving hemp across state lines. So let's see here. How does transport work when you go to another state, for example, grown in Vermont, but processed in another state? And then, somebody else asked a similar question. May a grower or processor transfer hemp to an out-of-state processor?
So there's no limitation on, for the second question, there's no limitation on a grower in the state selling out of state. We do have some, record keeping requirements with respect to that, just so we understand where crops are moving. Again, to see like, oh, why isn't it being sold in the state? And why is it being sold out of the state? And we understand that people have relationships. So it's not, the why maybe isn't important, but just understanding that. So there's no limitation on that. As far as like what one needs to do in order to transport crops outside the state. I'm first going to say that I work for the Agency of Agriculture in the state of Vermont, and I don't know all of the rules outside of our state. So I can't really say what another state would require. Like, do they require some kind of permitting to be able to transport hemp across their states, you know, within their state? I don't know the answer to that. It's possible though. So I guess my first suggestion would be is to, if you're transporting outside the state, to contact the other state and learn what they require. I also want to say that because we're operating under the 2014 Farm Bill, and we are operating with the definition of meeting the acceptable potency definition, which has both a 0.3 delta 9 THC concentration requirement, but up to 1% for total theoretical. I will say that that's a little more flexible, or is a different standard than what's outlined under the interim final rule that governs folks that have submitted a state plan under the 2018 Farm Bill. And so I just encourage you to contact the states that you're working with and the processors you're working with to make sure that they understand what you're shipping. Of course, if you're shipping something that has a total theoretical of 0.3 delta 9 THC concentration or less, that I believe is legal across the country. And your certificate of analysis, you know, if it shows that information, I believe that that's kind of the good information to share with whomever you're working with in another state.
Great. So there's a bunch of questions around lists. So maybe if you have them, Stephanie, you can just say yes, and we can put in the link. So the first one is, do you have a public list of processors?
We have a list. Yes, we have a list. You need to contact us and we'll give it.
And us is like you at your email, Stephanie?
Yeah, you can email me or agr@hemp. agr.hemp@vermont.gov.
Okay. Can we find out the addresses of the grain or fiber farmers?
No, we are prevented from sharing, we're prevented from sharing the location where hemp is being cultivated. But we can provide general information, but we could potentially do a selective search within the data we're collecting and just share the email addresses, the public information of those that are growing for fiber.
Okay. Are you looking for street address on labels?
We are looking for, let me find my rule so I can read it. The name and principal mailing address of the processor of the hemp product or hemp infused product. So it's a principal mailing address. If it's a PO box, if that's your principal mailing address, that's fine.
Okay. Here's some other, hopefully, quick ones. As a commercial storage facility that only stores other registered growers' processor crops, none of our own, are we required to report the movement of other crops through our facility on January 30th? That's not a simple one, is it?
No. Whoever asked that question, please feel free to email me.
Okay.
There were too many facts, and I wanted to make sure, I want to be able to give the question the time it needs.
Okay. So you know who you are. Please email Stephanie. People are looking for some worksheets. So somebody said, do you have a worksheet for processing lots? And someone else asked a very similar question. Can you provide a fillable spreadsheet to registrants to track process lots and the annual reporting requirements?
So we currently don't have those resources, but that doesn't mean we can't develop them, but I can't give a timeline for developing those resources. If the individual that asked that question wanted to email me as well, we could potentially just have a conversation just to make sure I understand the goal, and then that will help us determine the feasibility of actually developing worksheets for those purposes.
Okay. Let's see, I'm just checking on time. We got a few more minutes. So let's see here. There's a couple questions about hot crops. So question about mitigating hot crops. Under section 14, it looks like a hot crop will require corrective action. Is it written in the rules somewhere that a hot crop must be destroyed and that there is no other acceptable corrective action? And
So,
there's another question about mitigation. So
yes, so section 7.6, when a harvest lot does not satisfy the acceptable potency level, the grower must dispose of or destroy the hemp crop in accordance with section 14. I think corrective action is a term of enforcement, and it's how you correct or what action you take to correct the violation, which doesn't include the ability to mitigate or otherwise remove THC to make that the resulting extract compliant. The program is based on the fact that you are growing a crop that meets the definition of hemp and our acceptable potency level. And if the crop that's grown doesn't meet that, then there's no flexibility on the other end.
okay. There's a couple of questions about this 10/31, the October 31 date. So it says here, will hemp harvested by 10/31/2020 under our existing Vermont permit remain legal for storage, processing, transfer, and interstate commerce after the repeal date of the 2014 Farm Bill that's supposed to take place on 11/1/2020?
Yeah, so I'm not an attorney and I cannot provide legal advice. And that is clearly it applies to everybody, obviously. What I believe, and I don't have a reference, but I think USDA actually has a statement to this effect, that if it is harvested under under a pilot program, it's compliant with that pilot program, that is a legal crop, which is why record keeping is so important. It protects everybody. But I would have to go and find that link. I swear I read it on USDA's website. But my understanding is yes. But I encourage you to speak with legal counsel.
Okay.
This is Annette. Can I jump in for just a second?
Yeah. Yes,
okay.
please.
So I think that, like we started out in the introduction to the webinar, that there are some questions we really don't know the answer to, and we're going to be working on those. And I think the issue with regard to interstate commerce is a really important one, and something that we're going to have to go do some research on and really look beyond the Vermont Agency of Ag rules for hemp. So I am going to be spending some time looking at that. But I think, given the different standards, that's one thing. The other thing is that I think in terms of law enforcement, there are lots of law enforcement folks who have never heard of the Farm Bill, the 2014 or 2018 Farm Bill. So this is new, and I think different states are taking different tacks. So we're just going to have to sort of dive in and see what the state of play is to answer that question.
Great, thank you. We are almost out of time. A couple other questions about trace. When and how will Trace get involved with the administration of the Vermont Hemp Program? And will people need to re-register and get a new registration number if Trace gets involved?
So the agency is currently working with Trace to develop an online registration system that should make this an easy, registration an easier process. Also under the USDA interim final rule, they have required, and when the agency submits a state plan, and if we operate under the interim final rule, there is a convention for registration numbers that is beyond our control as a state. So yes, you will be getting a new registration number, but it is a requirement of USDA. It is not related to an online registration platform that the agency is developing with Trace.
Great. A couple others I'm hoping we can finish up on. One is, if we're already registered as growers, do we need to amend the registration to cover trimming and storage?
Yes. If you, well, yeah, I mean, if you did not register a storage location for your hemp crop, you should amend your registration to include that information. And then if you are trimming your hemp crop, you should be registered as a processor. And then all of the processor sections of the rule will apply to you.
All right. Okay, let's see. Is there further guidance on when the phrase "this product contains THC" is required on labeling?
If the product contains THC, then that is required on the labeling. If it's, and this might go to like, if it's minimal, do we need to put that on there? We haven't established, and I don't believe that I'm prepared to say that, like, if it's, what is negligible? I don't have an answer for that right now. We can certainly look into that. But if the product contains THC, that is required to be on the label.
Great. So one last question, and then we'll try to sign out here. And I think everybody has the contact information for folks. So, it's right there up. Please send more questions to the agency if you didn't get them answered today. So this is about Vermont branding. Can hemp receive a Vermont Grade A designation? ? If so, where can we get information to qualify for this designation?
So the agency had initially put in grades of hemp and attributed it to cannabinoid concentration. And that was in our draft rule. Based on comments we received during the rulemaking process, we removed that provision. So we currently don't have any grades of hemp established within the rules. What the agency has done, though, it has created or established the Vermont Hemp brand as a part of the rule. However, it's supported by our certified lab program. And until we get the this is something that, despite it not having a delayed implementation date, it is delayed by virtue of us not having our certified lab program up and running. But once we have that up and running, we hope to be able to offer this Vermont Hemp brand to folks in the state of Vermont that both grow and process their products within the state's borders.
Great. Thank you, Stephanie. We are on the we're over time. And I really appreciate it. You obviously are going to be getting a lot of questions. There's a couple more popping up. One, I think somebody was just saying that you can get an amendment form from the agency.
Yes.
You need to change your registration. Is that online?
Yes, that is on our website, and we can send it out easily so people can contact us. So feel free to contact me and I can email it out.
Great.
I'm happy to have contact with people. So few times this time that I actually have contact with people, so I'm happy to
Yeah.
folks.
Okay, well, I just want to remind everybody there'll be another webinar next Thursday at this time. There'll be some webinars also in July that are focused on pest scouting and management. Those have not been listed yet. And as was already mentioned, August and September webinars focused on testing and compliance. And some of the new certified lab information. So thank you, everyone. We really appreciate it. And hopefully we'll see you next week, too. Have a great day.
Thank you.
Thanks, Stephanie.